This morning on The Real Story, a mad dash to May 8th adjournment at the state capitol. We're giving you a detailed update on where the budget battle stands, plus potential new laws that will impact you, like changing what police can pull you over for. But none of the reforms come without controversy. We've got your insight into the conversations in the chambers. But first, the last day of scheduled Supreme Court arguments this term has left the bench with major constitutional questions, what some are calling the parade of horrible hypotheticals, as the justices debated the power of the president and immunity for Donald Trump. We're talking to a constitutional law professor to make sense of that and more this morning. Good morning, and thanks for joining us on The Real Story. I'm Emma Wulfhorst. We're taping this special segment on Thursday, April 25th, the last day of scheduled oral arguments in front of the country's highest court for a term full of highly controversial cases. Former President Donald Trump is claiming presidential immunity in this case in his criminal prosecution for election interference as a candidate who was also a sitting president, the incumbent. This put in front of a Supreme Court bench that has record dissatisfaction and distrust. Joining me now is Quinnipiac Assistant Professor of Law Wayne Unger, who teaches constitutional and criminal law, First Amendment and data privacy and security law. Wayne, thank you so much for being here with us.
Well, thank you for having me, Emma.
So there are a lot of people right now who are just tuning into Supreme Court arguments for the first time, and it can really be quite confusing for anyone, especially the general public who don't study law or politics. So before we really dig into this, I want to ask you what you noticed in arguments, specifically what legal, constitutional questions or answers should people understand as sort of a baseline today as they're following this?
Sure. So that's a great question. And the first thing I will say is that this court is always concerned with whatever it decides sets the precedent moving forward, because that's how our legal system is built. Our legal system is built on a common law system to where prior cases can be binding on future courts. So that said, today's constitutional question was whether the former president, Donald Trump, or any president moving forward has any level of criminal immunity with respect to official acts. And so it's important and it's a monumental decision because it not only impacts the former president, Donald Trump, but also every president now and into the future.
And of course, still no ruling. Today was only arguments, but that brings up another question. There's an understanding the timing of the justice's decision and the election are incredibly important and intertwined. Here are Supreme Court biographers saying a ruling against Trump, which pushes the January 6th trial after the election, is then essentially upholding Trump's argument and protecting him in the short term. The court system is vast. We see these cases get thrown back and forth. If the highest court doesn't rule in time for the election, can a criminal conviction anywhere else even stand in the case of the president?
Yeah. So, as you know, as many lawyers will attest, and certainly law professors as well, the best answer here is it depends. It depends on a number of things. So first is if Donald Trump loses the general election in November, then almost certainly will proceed eventually to trial in D.C. in the D.C. District Court. If he wins, once he's inaugurated in January of 2025, then we have a whole nother slew of potential legal and constitutional questions. Certainly, because the President of the United States directs the Department of Justice, and while there's the tradition that the Department of Justice remains independent and kind of stands away or keeps an arm's distance from the politics of the White House, I think it's very reasonable to expect Donald Trump, if he were to win in November and then gets inaugurated in January, he would direct the Department of Justice to drop the case against him. So that's one. Or two, he could pardon himself for these federal crimes because this is a federal criminal trial. All of those are potential kind of outcomes here. But I should be also clear that it doesn't necessarily impact the other trials that are going on around the country for him, like the one out of Georgia, like the confidential information case, or any other, the New York hush money case right now.
Right.
Those cases are violations of state law. And so for that reason, he can't pardon as a federal officer of the United States. The president can't pardon state crimes.
Right. And let's peel back a bit here. Obviously, this case was brought forward because of the former president's election interference charges. But we heard the justices really trying to underscore that today was not even really about Trump. Justice Alito saying perhaps most clearly, quote, whatever we decide is going to apply to every president. A serious constitutional question up in the air today in America, right?
Oh, absolutely. Because as I mentioned, we're a system that's a common law system in which past rulings can be binding on future courts.
Right.
So in this particular case, as the justices expressly stated, on the bench this morning, that there are a slew of hypotheticals that could very well become reality, depending on kind of what the justices rule in this case. They talked about, for example, bribery, right? And whether the president is immune from criminal prosecution if he or she accepts a bribe and then as a quid pro quo appoints somebody to, say, the ambassador of Japan. Well, the issue here is if a future president goes into the office knowing that they have some form of immunity, what will that become, right? So will that become a president who will push the boundary and break the law? Will that become a president who just understands and respects the law and kind of disregards the fact that he or she has immunity? It's a hairy situation, to put it lightly.
And you mentioned hearing a lot of hypotheticals, a lot of maybes, what ifs, and I think this is what the framers meant 237 years ago. We know law is meant to work on precedents. As you said, there are originalist justices who operate on the Constitution as written, but the Supreme Court is being faced, especially recently, with a lot of unprecedented questions and situations. This is where we start to get into, is the Constitution living and breathing or not? We've been talking to Connecticut lawmakers about the many gaps in laws here because we live in unprecedented times, like tech evolution, new crimes and challenges, and even in this case, a former president criminally indicted. How does the Supreme Court, particularly those originalist justices, keep moving forward when there's less and less precedents for them to interpret?
Right. So, this constitutional question, whether in this case, a former president is afforded any level of criminal immunity, that's novel in the sense that it's never been heard in the history of our country. And to your point about originalism and the justices who subscribe to an originalist belief or interpretation of the Constitution, we can look back at some of the records that existed at the time or the notes that were taken by the framers and hopefully figure out, well, what did they intend? And the arguments were on both sides today. So what I mean by that is you had Trump's attorneys today arguing that the historical understanding is that everyone being the framers, thought that the president is immune from criminal prosecution based off of something Ben Franklin said at one convention. And then you have, of course, the attorneys in Jack Smith's office for the Department of Justice arguing, well, actually, the historical understanding, if we look back over time, right, is that the president is not immune because we've always assumed that the president could be charged criminally for that matter. Then there's the other originalist argument, which is if we look at the nature of the revolution and how the United States or then the colonies rebelled against King George in the 1700s, that was fundamentally about, a monarch and rebelling against somebody who thought or who was above the law. And so this notion of no one is above the law is very much permeating throughout the United States history. Originalism is an interesting point, Emma, because it depends on, whose opinion you're looking for, what you think. And then to your other point about Connecticut, trying to apply a 1700s thinking to modern times is difficult, especially in the age of tech.
Right.
I know that as teaching data privacy, and so this is the challenge that the the 9 justices of the court have to grapple with.
You mentioned a lot of talk of the founding fathers trying to prevent the monarch in America through checks and balances, impeachment, et cetera. But then we have people in Congress saying impeachment proceedings have become mockery now and aren't necessarily effective in these extremist times. Justice Sotomayor admitting today these constitutional mechanisms could and potentially have failed. And that's why we have criminal law and what was the idea that no one is above it. The pushback from legal counsel was, quote, the ultimate check on the president is the goodwill and faith of democracy. But that faith in democracy is at a record low in really all of the polling data we look at right now. So the question kind of becomes, well, what now?
Yeah. So we look at the fundamental distrust in democracy or some feelings of upset over the way in which our system is structured. But I think if we focus, it depends on where we focus. And what I mean by that is we could focus, for example, on how Donald Trump's attempts to remain in office failed because there were so many safeguards, because there were so many checks and balances, right? And he's still facing those today. He's still facing levels of accountability today.
Right.
So on one hand, I understand and I respect the argument that, our systems aren't working or the checks and balances aren't playing out. Or, as you mentioned, Emma, impeachment and the trial in the Senate has become a political circus. Well, a couple of things. One, impeachment is meant to be a political remedy, and it's always been political. But two, there are other checks that I think are less obvious, possibly, to an ordinary person, that kind of prevented these crimes from actually being committed, or I should say the alleged crimes from actually being committed in this case,
Right.
and other checks that exist throughout our system.
Here, Connecticut's Senator Chris Murphy, or federal U.S. Senator, among others, has been outspoken, calling this Supreme Court the most radical the country's ever had. There are elected officials and law experts who have all suggested, even though the justices, as we've been talking about, are meant to be an objective judicial body, we have no choice but to view them as pretty political right now, perhaps even more political than they've ever been. What's your response to that?
So to be clear, and I'm going to try to take a neutral and objective analysis here to your question, Emma, and if we look back over time, there have been courts that have swayed one direction over another, who've swayed left or swayed right, so to speak. So the politics has always been involved in the court as well.
Right.
Let's go back to, say, Franklin Delano Roosevelt. FDR tried to pack the court. He asked Congress to expand the number of justices to 13 so that he could appoint more justices in order for his New Deal to be upheld as constitutional. So that in itself is politicking, right? Trying to lobby Congress to change an institution so that your stuff could get passed. And all of that is to say, this is not. I can understand the perspective that this is a hyper-political, hyper-activism court or activist court. And certainly there are cases, I think, that demonstrate that, such as Dobbs, which overturned Roe v. Wade, as a key example. But if we also look holistically at what this court does, and I'm not trying to defend the court, I'm just stating an observation or a fact here, is many decisions are unanimous decisions from the court. It's the decisions that we hear about are the 5-4 or the 6-3 splits, right? That are the more controversial issues. And so we believe that the court is hyper-partisan in a 6-3 conservative majority, but actually the data can lead inferences in the other direction. And I should also add, the justices flip all the time. So there are many times in which liberal justices like Justice Kagan joins the conservatives, and there are other times where justices like Justice Thomas joins the liberal wing. So I kind of disagree. I personally disagree with that category, like the broad categorization that the court is 100% all the time hyper political, when the data just doesn't support that.
Yeah. And our last question here, taking it to states as well, especially here in Connecticut, over the past few years, we've seen states create sometimes progressive laws and state constitutional amendments in response to, as you mentioned, some of those more hyper-political or controversial Supreme Court rulings, and for states sometimes too just fears of what the court may rule or appeal. Then we see these laws, whether it's about abortion rights or gun laws, discrimination in tech, end up seemingly in never-ending court challenge cycles. There's a cost to the state just constantly defending the same laws again and again. Legislators face fears and blocks to passing laws that they say seem to open up to constant court scrutiny. One example we've been talking about is the very question of whether marijuana can be legal in Connecticut or other states if Congress hasn't legalized it as a country yet. From your perspective, is there a point where litigation doesn't just enforce and interpret laws, but starts to maybe stand in the way of it?
Sure. No, that's a great question. I go back on, you mentioned earlier, Emma, checks and balances, right? This is how our system is supposed to work. The idea that we have two sovereigns, right? We have a state government and then we have a federal government. This is how our system is supposed to work, where if there's an infringement upon someone's individual liberties by the federal government, state governments can step in, right, and try to remedy or prevent or mitigate that infringement, and vice versa. If a state tries to infringe upon an individual right or liberty, the federal government can step in and again protect that. So that's another kind of check and balance that's in our system. And litigation is also a way in which we challenge things that may cause an injury to us. And we have high burdens and evidentiary standards in which you can't just present anything in court, right? It has to be reliable, for example, reliable evidence to where we can push back on potential overreach, or we can push back on potential infringements of individual rights. And all of that, again, is to say, Emma, in many ways, this is actually how our system is supposed to work, as frustrating as it may be for some.
Well, Professor Unger, thank you so much again. So many eyes on this right now. Thank you for taking the time to sort of break it down a little bit with us, something we'll definitely can continue to be watching.
Absolutely. Thank you for having me, Emma.
Well, there's still more to come, though, on The Real Story. Our local lawmakers don't have a lot of time left in this legislative session, but we're taking the time this morning to get into some of the priorities this next week and a half. As we get to the end of the session, what could lawmakers possibly pass? Could things like what police pull us over for change in just a short session? What has support and what doesn't? And are there any new solutions to the spending problems? We've got insight next. Don't go anywhere.